Every day in the USA, people find themselves in court.
Okay, back to Jonathan Connor.
We're going to sit down for a hearing, full-on hearing.
And we're going to do that next week.
It's up to Mr. Ham on that one, when he could be ready.
I'm doing the paperwork to file the new charge, Judge, so it should result in a felony, so that probably is going to slow things down a little bit.
Yeah, let me get to him here.
But if you want to get it set in by 3 weeks, maybe, I should have it resolved in that time frame.
All right, both of these are.
No, it's always like the elected
Each of these are second-degree felonies.
Yes, sir.
Yeah. Failure to report. Failure to provide verification of community service at a location other than failing to police anger management. Well, I mean, all of those are kind of important. Where are we on the what are we holding up for? There's a continuous violence against the family. Is that going to need to be heard?
That's the one that I.
The other ones are bad enough, aren't they? As far as this is true, failures to report.
We can
It
proceed.
looks like it's an absconding.
We can proceed on the administrative, but I figured you'd want the new charge.
Well, I'm interested. I need to know as much information about the person as possible. I mean, that can be wrapped up, but as far as there are 1, 2, 3, 4, 5 administrative violations that the probation officer is the witness. Let's move on that as soon as possible. Can we do it
Yes, sir.
today?
She's here, right?
You ready?
Yeah, he wants to, yes, we can do that right now, or not.
Okay.
Right now, but
Jonathan Connor, Finn. Thank you. I've got Christopher Davis and Charles Piles.
Davis, we have already fled. I need more time. I'm still working on that.
How much time do you?
3 weeks, 4 weeks.
Okay. Is 3 weeks going to be good? Okay. 3 weeks. Yeah.
Chance Palace.
Mr. Connor?
Yes, sir. I can vote.
Waiting for the deep thing.
I've got 2 cases here, sir. Styled the state of Texas versus Jonathan Bernard Connor in cause number 20-3519 and 20-35435. You are Jonathan Bernard Connor?
Yes, sir.
And you were here with Mr. West, your attorney and the state's attorney. Okay. You've had a chance to discuss all of this with Mr. West?
Yes, sir.
Okay. There's a first amended motion to revoke probation that was filed on May 12th of this year. You know, it's everybody ready to proceed today.
Right.
And raise your right hand, sir. Do you solemnly swear or affirm any statements you make during this hearing shall be the truth, the whole truth, and nothing but the truth, so help you God?
Yes, sir.
Lower your hand, sir. And each of these, we're going to take these up together.
That would be easy, Charlie.
Each of these similarly state that on July 24th, 2024, that would have been last year, in this court, you were placed on 10 years deferred or unadjudicated probation for the second-degree felonies of assault on a peace officer. That was the second-degree felony in each case. Is that true?
Yes.
All right. Allegation 2 in each of these motions state that you failed to provide verification of performing community service hours as required, as directed by the court in violation of condition 17 of your deferred adjudication order. Is that true or untrue?
Sure.
Number 3 states you were at a location other than your residence at approximately 2:35 a.m. on or about April 13th, 2025, in violation of condition 18 of your deferred or unadjudicated probation, which is going to be stand by.
Just checking it, the hours for the curfew, Judge. It's 10
Be
p.m.
inside your home every day between 10 p.m. and 6 o'clock a.m., except for employment purposes. Is that allegation true or untrue?
Yes, sir.
Are you okay?
You broke down.
And you're pleading true.
Yes, sir.
Are you pleading true to that one as well, voluntarily and because it is true?
Sir.
Number 4 states you failed to provide verification of entering and successfully completing the anger management program as directed by the probation officer. Is that true or untrue?
Yes, sir. Can I say something?
Yeah.
Well, you're gonna get a chance to say all that. We're gonna have.
Yeah, you're going to.
Is
Is
true or
that
not?
true or untrue?
Yes, sir. True.
Okay. Are you pleading true to that voluntarily and because it is true?
Yes, sir. Absolutely.
Okay. This next one states you failed to pay court assessed fees as directed. As of April 15th, 2025, you were $855 in arrears in cause number 2035195 and $135 in arrears in cause number 35435. Is that true or untrue in each case?
True.
Were you able to pay those? Did you have money to pay them?
Not at the time, sir. I'm sorry. I did.
Okay, that's okay. If you're unable, if you're able to pay and you didn't pay, that's a problem. If you're unable to pay and didn't pay, you don't go to debtor's prison. We don't have that. So you weren't able to pay.
No,
Okay. The number 6, finally. This states you failed to report to the Jefferson County Probation Office for the months of February, March, and April of 2025 in violation of your probation orders in each case. Is that true?
Yes, sir.
So, are you pleading true in allegations 1, 2, 3, and 6 in each of these first amended motions to revoke probation?
Judge, that's not the right numbers. Should be 2, 3.
No. Sorry.
2, 3, 4.
Yeah, what am I doing? Yeah. All right. There's no agreement here, correct?
Exactly.
Okay, go ahead. Defense.
Your Honor, do you want the state to put on you want to go first?
Well, he's pleaded true in each of these
Okay.
voluntarily, knowingly, intelligently, and that's all.
I'm sorry, I was right.
The
The other way
now,
around.
the state gets to be heard too, but I think
I
the
understand.
ball is now in your court
You
since
absolutely-
that's enough by a
Yeah.
preponderance of the evidence or greater to revoke his probation,
Yes.
unless something that changes my.
Yeah.
Okay, go ahead.
Let's talk about each one of these individually. Next time, community service. Had you done any of your community service at the point you were arrested? Have you done any community service?
No, sir. I haven't done
Okay. Well, why haven't you done any community service?
The only reason why I haven't done it because, first of all, transportation was kind of not there.
What do you mean by that?
Meaning like I didn't really have the transportation to be able to move around the way that I needed to once I was released from Jefferson. Yeah.
Okay.
So and also it was a hard time at the time because my mom was sick, so I was trying to spend more time with her. But she actually died a month after that. And then really I just think
Let me work it. Okay. So after you were released and went back home, your mother was having health problems. Is what I'm getting.
Yes, sir.
Okay. So I was trying to get you to say. Okay. All right. And then so you were helping take care of her.
Yes, sir.
Okay. What month did she pass away? When did she die?
she passed in March. March 1st, 2025.
Okay. All right. So you were having trouble getting doing community service and getting out to do that because not only transportation, but also because your mother was sick and all that.
Yes, sir.
All right. I'm gonna come back to this one, but anger management. Had you done the anger management class yet?
As far as anger management, I just didn't know where to actually go. My probation officer, she never really told me exactly where to go. But but that's not her fault. I'm not blaming.
Sounds like you're making it our fault
Okay,
to
well,
me.
let me take that back. I didn't know where to go to do the anger management, so I didn't get started. I will do it.
You ever thought in about a year or so of all of that maybe you ought to find out?
Yes, sir.
Okay, go ahead.
So the point is that you still will do it if the court continues on probation. You'll go take that class as soon as you can. Okay? But you were kind of under the assumption that you're supposed to be told where to go, and that's not the way it works, right?
I guess so.
Okay, all right. That's what I'm getting at is that you were just waiting for somebody to say, "Hey, go here," but that's not their responsibility. You understand that now?
Yes, sir.
All right. And so you will seek out and do that if you're supposed to. Okay. All right. Now let's talk about the missed February, March, and April. You missed some appointments with your probation officer. Is that you said that was true earlier?
Yes, sir.
But why did you miss February, March, and April specifically?
Okay, February is the time where I was somewhere homeless, and that's when my mom was in the nursing home. And that's why I was homeless, because she was actually getting evicted from her apartment, and she was living in the nursing home in Port Arthur. And so that's where I was pretty much staying at. Well, not staying, but back to work as much as I could.
Back and forth from where?
Port Arthur,
To where?
so I could stay with but she was in nursing home in Port Arthur.
So you were living with your mom, but due to the fact that she went to the nursing home, y'all all got evicted, correct?
Yes, sir.
Okay. So you didn't have a place to live at that point.
No, I didn't.
And then in March is when she passed away, correct?
March she passed.
All right. So, but up to that point, you were making your meetings before that day, correct?
Yes, okay.
All right. You hadn't missed any before that. You were able to, despite transportation issues, you're still able to make those appointments.
Yes,
Hold on for just a second, because I'm confused. It sounds like you're dependent. I mean, how old of a man are you, sir?
I'm 35.
35 years old.
Yes, sir.
You're 35 years old.
I
I'm sorry, you've been an adult more than half your life.
yes, sir.
Well, you got to be independent, sir.
Yes, sir.
I mean, we all have to take care of ourselves here. And is there any reason why you're unable to take care of yourself?
There's no reason.
There's no reason. So, I mean, you work. You got to work. You got to follow the rules. You got to be independent.
So,
You have a family?
yes, sir.
Do you have any children?
Yes, sir. I got 2 children. I was going through a breakup as well, so I mean,
But when was the last time you were employed?
right the last time,
What were you doing?
we working.
Making
I was making like $25 an hour.
that's over 50 grand annually.
Yeah,
It doesn't look like it. You 100% dependent, but you're able to do things and make 50 grand. I mean, that's independence, but it's, I mean, you keep saying your mother. You can't blame this on your mother, on the situation. Can you really?
not in reality.
No, you got to
It's just,
take responsibility for your life as an adult, like we all do. Sir.
yes, sir. No problem.
There's one more going. Regarding the curfew, you were out past your curfew on this April 23rd. April 13th. Okay, I'm sorry. I can find the date. You were out past your curfew. You understand that, correct?
Yes.
Why? You told me why, but I want you to tell the curfew.
We was coming from a family, but we broke down. She ran out of gas, and the brother I was with, she didn't have them running to go get gas, and she wanted to argue. I was still, it was a big deal, and long story short, we broke down. I was late.
Okay. Anything else?
No, you're not passing this.
Okay. Passes this. Any questions? Of the defendant?
Yeah.
Um, um, does the state wish to present any information to help the court and from the probation officer? Okay.
I would call Miranda Baeza.
Raise your right hand. You solemnly swear or affirm the truth, the whole truth, and nothing but the truth, so help you God. Thank you. Lower your hand.
Go ahead and state your name for the record.
Liaison.
Are you the officer for this gentleman, Connor? Have you been that section of probation? All right, so let's work backwards. Did a second administrative hearing, not you remember that?
Yes, sir.
And I'm reading the notes. Is it basic failed to report for resulted as an absconder? And administrative hearing, it indicates that he was staying in contact with you by telephone.
For the most part.
Was he offering excuses as to why he wasn't appearing?
Yes, due to lack of transportation.
Kind of like what he was telling the judge just now.
Right.
And how many specific office visits did you reschedule where he missed as far as that time frame is concerned?
Many.
If the administrative hearing indicates that there were 8 different office visits, does that sound accurate?
Correct.
So it sounds to me, ma'am, and I don't like assuming anything. It sounds like you were working with him, trying to listen to his excuses and giving him opportunities to come in.
Yes, sir.
And he failed to do that. And do you feel like you worked with him well enough to where he should have been able to make some of those visits, if not all of them?
I do.
Let's go to the other accusations that are in here. You heard him initially say that you didn't tell him where to go about the anger management program. What's the truth?
I provided him an online referral for the course at his initial office visit with me in September of 2024.
So that means for the last 11 months, he's known where to go.
Correct.
What's been his excuse about not doing community service hours?
Lack of transportation.
All throughout. But he managed to come and see you before we went to the non-reporting, right?
Sporadically seeing
Yeah.
him. Correct.
Has it just been a problem for him from the beginning?
Yes, sir.
And he uses that as his excuse for not doing community service hours. What are options for people that have transportation? I know y'all have them. What are they?
He could take city bus transportation.
Don't y'all have days that you designate where if they can get to a location, they can kind of double up on missed hours, those kind of things? Projects is what I think they're called.
Correct.
Did you advise him about that?
He was given the CSR coordinator's phone number to be able to contact her regarding those projects.
So he had options.
Yeah.
Just chose not to do it.
Mhm.
Are you aware that this original charge arose out of a domestic call out where these police officers were investigating whether or not he was assaulting a girl at that original offense?
Yeah.
Is that part and parcel why we wanted him to go through the anger management program
Yes.
and didn't make any efforts? Did you encourage him about that?
I did, and I asked him why he hasn't completed the course during our office visit.
And what responses do you recall getting in that regard?
Lack of transportation, lack of funds to be able to pay for the course.
Do you want him continued on probation, Matt?
If the court elects to continue him on probation, I suggest that he be placed on a high medium risk caseload.
That wasn't my question. My question was, do you want him continued on probation?
At this time, due to the lack of progress he has made on probation, I don't see him progressing.
Right. If the judge orders him, obviously you're going to work with him.
Yeah.
But from your hands on dealing with him, it doesn't look like he's going to do what he needs to do, right?
Right.
Best witness.
Before the this February, March, and April of 25 that he didn't check in, had he been doing pretty good before that?
Not consistently reporting.
Okay. What do you mean by that?
He was reporting very sporadically, and I had to work with him and reschedule many times for him to be able to come in.
Okay. But he did come in those times, right? Whenever you worked with him?
Correct.
All
But
right.
it was at the very last minute. before he became an absconder.
And on the curfew issue, he told you why he was past curfew. Did he ever tell you that, or is today your first time you heard that?
I was made aware with the office report.
Okay, all right. And community service, he still has time to do that, correct? I mean, he still has, how many more years he has left on probation? What, 4 more years? Is that correct? Yes, he's getting 5 years, so he's been on probation for about a year. Is that right?
He was
He has the
given
remainder of
10 years.
10 years?
Mhm.
I'm looking at the wrong one. I'm sorry. Different person. 10 years. So he still has time to do the rest of the community service, correct? He's put back on probation. Okay. What I'm getting at is the judge determines he can go back on probation or continue on. He has time to catch up on those hours, correct?
Correct.
Same thing with the money if he can pay. And then also anger management. He can still do anger management now, correct?
Right.
Okay. So the big issue we have is this curfew in the February, March, and April. Okay. Pass it on to Charlotte.
Nothing further. This witness, Judge.
Okay. What is this allegation number 1, the continuous violence against the family? Is that formally filed?
That's what I was informing the court before we started this. It has not been formally filed. That detailed. I've talked with the detective and that paperwork on its way, and we just process it. It's a felony for indictment. What concerns me most out of that PC, it's not just one accusation. There's 5 different calls numbers when you include the PC, that there have been call outs about domestic disturbances. So you can see this is my
Copy that?
Not yet, but I'm sure I'll be up. Because it has not been filed yet. My argument on that, Your Honor, is that this is evidence put on regarding this. There's been this issue, and I would suggest the court that rises or falls on a separate thing.
I'd gladly recess this and I'll get the evidence to present as far as that's concerned. We moved forward today because I was told that we wanted to resolve as far as the administrative hearings, but I know it's a phone call away. It's a resetting as far as this is concerned. I've talked to the detective. I'm aware of what the evidence is. I intend to move. When that case gets indicted, it's going to be mine.
Okay. When does this tend to file this as an amended motion to revoke probation then?
But Judge,
Second amendment.
it was originally suspended.
Oh, it is. Yes. When can, let me back up. When can we recess this to present some more evidence on that allegation?
Whatever time frame you want to give me, Judge. I know I won't have an indictment if you did it, say, later this week,
Necessary.
but I will need to receive it and share the evidence with defense counsel. I think anything within a 10-day period is reasonable
10
for
days,
both
good.
of us to do it.
Okay, we'll reset 10 days, please. And we'll pick up, we're going to continue this hearing and then pick up on the proof on allegation 1 of this.
Thank you, Judge. I
All
appreciate
right,
that.
anything else? Then we're in recess on that. Thank you.
Not.
Mr. Connor?
These cousins, so what happens to we'll sit right here.
Thank you, sir.
Okay.
All the other two, Mr. Connor. Okay, have a seat right over there, sir. Thank you. This is a continuance from June 16th?
Yes, sir.
All right.
You gave me an opportunity to present evidence on count 1.
20, the case calls, the court calls cases 20-35195 and 20-35435 In each case, it's the state of Texas versus Jonathan Bernard Connor. Mr. Connor is currently on deferred adjudicated probation for assault on a peace officer, a second-degree felony in cause number 35195, and also another assault on a peace officer in 35435. Now, we started a hearing on for the first amended motion to revoke unadjudicated probation in each case which had been filed May 12th of 2025. The court swore the defendant in and over the fact that the defendant in each of these motions was alleged to have been placed on deferred or unadjudicated probation for 10 years in these two cases on July 24th, 2024. And the defendant answered affirmatively. Then the defendant entered pleas of true to allegation number 2 in each case, failing to provide verification of performing community service hours as required for probation. 3 in allegation 3 in each of these motions in each case, which alleged he was at a location past his curfew by being at a location other than his residence at about 2:35 a.m. on or about April 13th, 2025. And he entered pleas of true to allegation number 4 in each motion, which alleged he failed to provide verification of entering and successfully completing the anger management program, and entered a plea of true to what's called first amended 6, number 6, in the motion to revoke probation, failing to report to the Jefferson County Probation Office for the months of February, March, and April of 2025. All of those in violation of the deferred adjudicated orders in each of these cases. All right. The state, we continued this hearing and the state has additional evidence to present.
Yes, Your Honor.
All right. Again, the defendant, his attorney, Mr. West, and the state's attorneys are present. Go ahead, Sting.
Yeah, at this time we'd call Clerk Smith.
And this is going to be evidence as to
One.
allegation 1, committing continuous violence against the family on or about April 13th, 2025 in Jefferson County, Texas.
Yes, Your Honor.
As alleged in each of these motions is violation number 1 of his probation order.
And I will inform the court my intention is to prove up the assault that occurred on April 13th.
Okay.
The nature of that particular charge would require evidence as to all of them, so I'm relying upon the lesser included offense. All right, sir, state your name for the record. And what do you do for a living?
Sworn police officer since January.
Yeah, help them with the microphone too. Yeah, thank you. It's what we call
I
it.
didn't realize that part you were sitting back. I wasn't paying attention. Let's move it up a little further.
Yeah, we have
an extra little more.
What we call a directional microphone, and you have to speak right into it, but it works when it just doesn't catch surrounding voice.
Well, you said you're a certified peace officer
Since January 24th.
and working for which,
Worked for the Beaumont Police Department.
all that time frame, sir? Or?
No, sir. I worked for the Beaumont Police Department and also Mount Bellevue Police Department.
So were you working in that capacity back on April 13th of 2025?
Yes.
And did you receive, what shift were you working?
Midnight shift
All right, so that covers what time frame?
from 9 p.m. to 7 p.m.
So did you receive a call out at about 2:30 in the morning?
Yes, sir.
And to what location?
Purple.
Please.
The address was 2950 Dowling Road, CBS.
Is that here in Beaumont, within the Beaumont, Texas, within Jefferson County, Texas?
Yes.
And again, that time frame was 2:30 in the morning, correct?
Yes.
What was the nature of the call out?
In regards to a disturbance.
So you arrived on scene. What did you do?
and with locating the two parties involved in the disturbance inside the store.
They were inside the store.
Yes,
And you saw both of them there?
yes.
And who were those two individuals?
One was a Jasmine Victoria, and the other was a Jonathan Compton.
So let's start with Mr. Connor first. Do you see him in the courtroom here today?
Yes,
Can you point to him and identify something he's wearing?
and the virgins.
Your Honor, may the record reflect he's identified the defendant, Jonathan Connor.
Yes, it will.
All right. So you see the two people. What's the next thing that takes place inside the store?
And speak with Mr. Collins.
And what happens with Miss Victoria?
She goes to speak with my partner,
And who is that?
Officer Dupont.
And he's here to testify as well, right?
Yes,
So is that kind of normal when you got two suspects in a disturbance to separate them,
yes, sir.
gain information?
Yes, sir.
Did you do that with Mr. Connor?
Yes, sir.
Did he make any admissions about the offense that we're here talking about?
No, sir.
What was his basic explanation about what took place?
He stated that they both got into verbal argument.
Nothing physical, correct?
Correct.
So you've gotten your version. What's the next thing that you do, sir?
Then I go speak with my partner, who's speaking with the other party.
Did you overhear him talking to that person?
Yes, sir.
And did you make it a decision? Did you make a legal decision moving forward based upon what you heard?
Yes, sir.
Okay. So what did you decide to do?
Based off of the information that was provided, decided to take Mr. Connor in custody for assault and violence.
Did you actually overhear her say that she wanted to press charges?
Yes,
Objection, Your Honor.
Just a
I'll get into the specific statements and reasons why I want to do that with a separate witness, Judge. All right. So when you stepped out to visit with your partner and get more information, where was Mr. Connor?
Mr. Connor was inside the store.
And what was he doing at the time that you left him in there?
I believe he was continuing with grocery shopping.
In hindsight, was that a good decision to leave him there?
No, sir.
So how long were you outside and determining that he needed to be placed under arrest?
It was probably a few minutes.
So you go back into the store. What do you see?
Did not see Mr. Connor.
No longer at the checkout.
No, sir.
Was he actually in the process of checking out groceries from CVS
Not when I walked victim for.
when you left? Was he?
Yes, sir. When I left.
Were those groceries still at the checkout?
Yes, sir.
Did you determine where he was?
We ended up locating him in the bathroom.
Okay. And did you place him under arrest at that stage?
Yes, sir.
Did he give you any problems?
No, sir.
Is that pretty much the extent of your dealings with him there at the scene?
Yes.
Now, I think I asked you this earlier as far as when you initially interviewed him, he didn't make any admissions about the offense.
No, sir.
Did he make any admissions later as you placed him under arrest or even when he was in your car, custody, the ride to the jail, any time in that time frame?
I don't recall.
No further questions of this witness, Judge.
anything? Defense?
Just a quick question. When you placed him under arrest, you said there was no issues, correct?
Correct.
He was cooperative and went with you with no problems.
Yes.
Okay. Polite and as can be in that situation.
Yes.
Okay. Pass witness.
May I approach, Judge?
Yes.
All right, I got you to identify this color. I'm going to show you what I marked as state's exhibits 1, 2, 3, and 4. Do these photos appear to be representations of Miss Victoria?
Yes, sir.
Is that how you saw her that evening?
Yes, sir.
Do these photos indicate injuries that she suffered?
Yes, sir.
And did you see those injuries that night?
Yes, sir.
Do all those photographs, states exhibits 1 through 4, truly and accurately represent everything that you saw that night on April 13th, 2025, there at the CVS pharmacy in Beaumont, Jefferson County, Texas?
Yes.
Nobody added or deleted anything in here.
That's
And you feel the fourth that this is in fact Miss Victoria in the injury she's reportedly suffered on the
yes.
interstate exhibits 1 through 4.
Objection, Your Honor, I've seen this.
Admitted.
Oh, then to the court. Oh, we'll use them film and stuff with this. No further questions of this one.
That's a further objection. So.
Can this man be excused?
You can, Your Honor.
You're excused. Thank you. Next, please.
Officer Heath Holmes.
Have a seat. Thank you.
State your name for the record. Heath Holmes. What do you do for a living, sir?
I'm a Beaumont police officer
How long have you worked as a Beaumont police officer?
since December of 2022.
And were you working in that capacity back on April 13th of 2025?
Yes, sir.
Yeah. What watch were you working?
First one.
And is that what? Tell me the time frame.
It's 9 p.m. to 7 a.m.
Right. Did you receive a call out to go to a CVS here in Beaumont within Jefferson County, Texas on that date?
Yes, sir.
Was that at the CVS located there at 2950 Dallin Road?
Yes, sir.
What was the nature of that call out?
It was a disturbance.
And what did you do when you arrived there, sir?
Me and Officer Smith went up to the front of the business. We didn't see anyone outside. It was flagging us down. We walked inside. We saw 2 customers inside the store that we just found with. They complaining and supposed actor. That was involved in the disturbance.
So was the timing of this incident around 2:30 in the morning, sir?
Yes, sir.
I think you were in the courtroom when I was talking to Officer Smith.
Yes, sir.
All right, so you know that states exhibits 1, 2, 3, and 4 are in evidence. You recognize those items?
Yes, sir.
Is this in fact the lady that you've been that's represented here in states 1? Is that Miss Victoria?
Yes, sir.
And Officer Smith indicated that whenever y'all came in, that he took the responsibility of talking to Mr. Connor, and you took the responsibility of talking to Miss Victoria.
Yes, sir.
Is that true?
Yes.
So, do you see Jonathan Connor in the courtroom here today?
Yes, sir.
Can you point to him and identify something that he's wearing?
Wearing a red shirts.
He's identified, and the record reflects that he's identified the defendant, Jonathan Connor.
Yes, he will.
All right, so you walked outside with Miss Victoria.
So,
Did you say you walked outside with Miss Victoria?
yes, sir.
So were y'all trying to separate these 2 individuals?
Yes.
Is that kind of the norm and the procedure for domestic disturbance?
Absolutely. We try to do that every time.
And describe to the judge what her demeanor was.
It's been a little while, but from what I can remember, she was, I don't want to say amped up, but very, she was very like off-puttish, I guess you could say, and kind of just didn't want to be, I get scared, I can say.
Scared.
Timid would be a better word for it. She just didn't.
Did you see those injuries that are depicted in States Exhibits 1 through 4?
Yes, sir.
And did you know that you were there investigating potentially an assault situation?
Yes, sir.
So took her outside. Where did you continue to talk with her?
Initially, we just walked outside, and then being that she was so uncomfortable, I could tell. I asked her if she wanted to sit in the back of my car, if she was more comfortable there. She said yes. She sat in the back of my car, and that's whenever I began talking with her.
Was she forthcoming about what happened to her?
Yes, sir.
And during the time in which I'm going to ask you about some of the statements that she made, and I want the court to be educated about whether or not she was in an excited state or whether or not she was just giving you a present sense impression of what took place. What's your opinion about that, sir?
Can you answer one more time?
Was she in an excited state? You described timid, you described scared. Did she seem reluctant to give you the information?
That's a much better way to put it.
Okay. Was it because you're a police officer, or in your opinion, or is it because of what she dealt with?
I think it was more so, it could be a combination, but it is very common. So I think it was more so the situation that she was in.
Did she seem to have recently been through the events that she's describing to you?
Absolutely.
And what, in your opinion, was she giving you an impression of what those events were?
Yes.
And was it from, how recent were the events that she's describing to you?
She described several events. If I remember correctly, three dating back a week, or three different times. Specifically, the one that we focused in on.
Objection, Your Honor, hearsay.
I'm not going into the statements he's giving backgrounds at this stage, Judge.
Just want to make sure that he doesn't talk about it.
Go ahead. I'm laying the groundwork to get into the hearsay statements.
Yeah.
So she's giving you, as she's talking to you, she talks about this has occurred over days.
Yes, sir.
So just as, did she get as to what happened that night?
Yes, sir.
Did she tell you details about what and when those things occurred? Well, let's be specific. Did she tell you how she got these in?
Yes, sir.
Did they happen on a recent situation from what you're looking at here?
Yes, sir.
Did it fit with what you saw here in states 1, 2, 3, and 4?
Yes, sir.
So timing, officer, is what I want to get back to. As she's relaying this information to you, did it happen hours ago or minutes ago?
She described both. It was an hour before, and then also while she was inside the store.
So y'all got a call to go to the store, and it sounds like something happened then, right?
It sounded like a continuous event up until we were at the store.
Gotcha.
I'm sorry, from about an hour before on up until whenever we arrived.
So hold that thought, Officer, for 1 second. So these descriptions, these statements that she made, did they describe an event or condition that either occurred immediately before or sometime leading up to it?
Up until the call?
Yes.
Yes, sir.
And do you believe that she was under the stress of that event as she's relaying it to you?
Yes, sir.
I mean, it's literally minutes before you guys got there, right?
Correct. Yes, sir.
You know, I'm going to tender that the questions I'm about to ask meet the exceptions under 803. 1 and 2, specifically statements that she made that we've been building around that she told this officer took place that night.
Your Honor, I would object to those statements. The exceptions to the hearsay are regarding statements made by a defendant. These are questions or answers she's giving to questions. He's asking her about what's going on, not that she's just excitedly uttering, "Oh my God, he hit me," or something like that. That would be different. That's what excited utterance and those exceptions are for when police officers show up or people show up and somebody's making statements unquestioned or provoked. In this situation, these are not excited utterances or exceptions to hearsay because these are him pulling her outside to question her about what's going on. And that's what the rules of hearsay are, prevent people from making statements that are made outside of court. We don't have the victim here to cross-examine and to find out what's going on here. So I would say that these are hearsay and they do not fit the exceptions to hearsay.
This court was on the committee that wrote the rules of evidence. Okay. What wrote the rules of evidence. And it is clear hearsay, as defined in hearsay, is generally inadmissible. We carved out 24 exceptions to that rule, not the least of which, or what the state is contending, and were the very first two that were written: present sense impression and excited utterance. If those fit the definition, they are clearly an exception to the rule against the admissibility of hearsay. In other words, they are admissible. But let's be clear what each of these are defined as. Excited utterance exception, and then present sense impression. An excited utterance, again, is the product of a startling event, and the statement is made while or immediately after being perceived by the declarant, and it is describing or explaining an event or condition. As to that is concerned, this court's a little unclear about what the timing is on that. I'll give the state allowance to make it clear. Excited utterance. Okay. An excited utterance on the other side of the coin there as number 2 exception. It's, a present sense impression. A present sense impression is distinct from an excited utterance and requires a statement describing an event or condition that is made while or immediately after the declarant perceiving that event. And we're talking about present sense impression, number 1. Excited utterance is a statement that relates to a much earlier incident. So the timing is not immediately or spontaneous, but can relate to an earlier incident that triggers a statement being made by the declarant, the person perceiving it. And the test is, was the declarant still under the stress of the excitement that event had occurred that caused the declarant to make the statement? So an excited utterance can come about much later than the present sense impression, which is what is happening immediately or at the time or immediately thereafter. Both are admissible, depending upon the circumstances, if it fits the element. Go ahead, Steve.
All right. So, officer, I know that she made statements to you about events that led up to this particular night, but for the purposes of what happened here and what she said, I want to focus in on what she told you about what happened right there at the store minutes before you guys got there. You understand?
Yes, sir.
All right. So that kind of helps us deal with the timing of these incidents, right? I'm not asking you to parrot back what all she said, right? But I want, in my attempts here with questioning, I want to focus in on that for the purposes of our timeline. You understand where I want you to go?
Not for the timeline alone.
All right. So I'm aware that while she's talking to you, that she told you about events that happened days before and things that led up. Am I right about that?
Yes, sir.
Okay. I also believe, based upon what you've said, that she told you what immediately happened that led up to y'all getting there and the reason why you were there.
So the event that we're called there.
I want to limit it to just that,
Yes, sir.
if I can. All right. So, did she describe to you the assault that occurred there at the CVS pharmacy?
Yes, sir. She did.
What did she say happened?
Objection, Your Honor. You made the ruling. Objection hearsay.
All right, I'm going to allow it for the purposes of the court hearing as much information about the circumstances to make a decision on your objection.
I think.
What she telling you happened right there at the CVS?
Yes, sir.
What did she say happened?
She said that she was assaulted by Mr. Connor.
Did she go into how he did that? Like,
Yes, sir.
okay.
She said that 3 to 5 times she was punched in the face which more specifically, she said that the large curving bruise that's coming from her forehead above her right eye, that was caused by being punched 3 to 5 times by Mr. Connors.
So when we look at State's Exhibit 1, this is the lady that we're talking about, right? This is the lady that you're talking to.
Yes, sir.
Did you take these photographs?
No, sir.
State's Exhibit 2. This here is that goose egg is what I'm calling it.
Yes, sir.
Is that what you saw that night?
Yes, sir.
Did that fit with what she said? That she was struck 3 to 5 times by Mr. Connor. That's what Paul said.
Yes, sir.
Did she describe to you how the injuries occurred on this?
Yes, sir.
What did she tell you? First off, before you go into that, was it something that happened that night,
Yes, sir.
recent in time,
Yes,
there at the CVS?
This was from a specific incident, so we're hopeful.
Thank you. I want to work within that same room. So how'd she get the bruise that we see in stage 3 and in stage 4 that appears to be on her right arm?
Yes, sir.
How'd she get that?
She said that was from Mr. Connor and Brandon. Right?
Is that the extent of the statement says she made to you about merely in time frame that the assault that occurs on April 13th?
Can you ask it one more time, sir?
I'm trying to make sure that we've gotten all the statements about what happened to her that night at the CVS.
Yes, sir.
I know she told you about other incidents.
Yes, sir.
We're not going into that right now. And I would tender that that's the testimony that I'm offering under those exceptions. I have more that I want to go into him, but not as to if there's some exceptions.
I still have my objection on it.
I got a problem with it. It's still not clear in the record. The timing and the most on present sense impression, again, that is truly based upon the timing of the event. It's made while or immediately after the declarant had perceived it. I'm still not getting any information when the event occurred and when she is talking to the witness. The excited utterance. The key there is the defendant, is the declarant still under a state of stress of the excitement that had occurred, which caused the statement to be made, which could be a while after the event. The question is how is the declarant, what condition is the declarant in?
I understand, Judge. If I might.
Go ahead.
All right. So in your discussions with Miss Victoria, did she tell you when those injuries took place?
Specifically the ones that you showed me pictures of was she told me it was from that night. I don't recall where exactly they occurred, but she said within it was about an hour prior of our conversation, which we'd probably been on scene for 10 to 15 minutes. So I'm not sure.
So within an hour,
Yes, sir.
did she indicate if it had occurred at anywhere at any other location other than the CVS?
Yes, sir.
And that was that particular night too.
Yes, sir.
Correct. Did she indicate that did any of these injuries occur right there at the CVS?
Well,
So when you said that she was struck 3 to 5 times in the head,
yes, sir.
that's the how of how she got states that it was 1 and 2. When is the question?
Correct.
Did she tell you when?
I'm sorry. No.
Sir?
Like where is where where I'm not sure when she's fully within an hour.
Within an hour.
Yes, sir.
That's true for states 1, 2, 3, and 4.
Yes, sir.
All right, so let's move on to the second. Second part of that question that I'm submitting, sir, is was she under the stress of that excitement? Was she still working underneath the stress of this incident that she described to you, in your opinion?
Yes, sir.
Why do you say that?
Based on her demeanor, her actions of not only was she trying to get further away from, I tried to bring her into the, I got press at the front doors and she just kept on trying to get further and further, trying to get in, then we got inside of my car. Not usual. We don't want to get in the back of the police car, but she wanted to get in the back of the police car to even talk to me.
And she stayed in that state of being through the time frame that you were talking to her?
Yes, sir.
And do you feel like she was still relating the events and the conditions that took place?
Yes, sir.
And in your opinion, still under the stress or excitement of that particular event,
Absolutely.
which from your understanding was something that occurred sometime within the hour of whenever you got this statement?
Yes, sir.
That's what I have to.
Continue my objection, Your Honor, and to address each one of these exceptions of hearsay. As far as the president's impression, I'm sorry, Your Honor, this was not made. It can either be made while or immediately after. It's not made while, so we don't.
The
even
question is within an hour, and
is
it's
that
certainly not while it's happening.
right? So it goes to the next part is it immediately after. I would argue that an hour later is not an immediate time right after that. It's one thing if they show up and it just happened right before they showed up, like
Okay. Go to the next one.
Okay. As far as excited utterance, Your Honor, these statements for her were not made out of excitement. They were made as response to questioning. This is not an excited utterance. I would argue that an excited utterance is more described as, like I said, the officer showed up, she comes around the store going, he hit me, he hit me, he hit me. That's an excited utterance, and there's no argument. This is where they found these individuals together in the store, broke them apart, pulled her outside, put her in the car, started asking her questions, and then she gave information. This is not where she was just voluntarily giving information to the officers. That's an excited utterance. This is an excited interrogation, and that's not one of the rules or one of the exceptions to the rules. This is still everything she said to this officer is still hearsay, Your Honor.
Okay. Overruled. That's not the intent. That's not the way it's worded. Excited utterance is called excited utterance. It's again a statement relating to a startling event or condition made while the declarant was under the stress of the excitement that it caused, which the witness has clearly described. It fits that definition, and your objection to present sense impression is sustained. Your objection to excited utterance, it's overruled. It is an exception to the hearsay rule. It is admissible. Go ahead, Steve.
So your partner comes out of CVS, or y'all were riding together. Officer Smith comes out.
Yes, sir.
Do you hear him approach?
I don't recall if I heard it or not.
Do you recall asking her if she wanted to proceed with charges? And
Yes, sir.
those are all normal steps and all, right?
Yes, sir.
You finished up your investigation, correct? As far as that discussion and all. I used the wrong
The
word.
time being, yes, sir.
Yeah, I know there's more that's coming. But you finished your conversation with her,
Yes, sir.
made a decision to move forward with probable cause for arrest.
Yes, sir.
Did y'all then move forward to do that?
Yes, sir.
All right. So again, you were present when Officer Smith talked about this. Did you follow him in to help locate Mr. Connor?
Yes, sir.
Where was he?
Mr. Cross,
Yes.
he was inside of the bathroom.
So tell the judge why you found that out of the ordinary that Mr. Connor was in the bathroom.
So they're checking other groceries, there's other groceries up on the counter inside the basket. Officer Smith, whenever he came outside, he left him there to finish buying his groceries. Because from his understanding, what he was told by Mr. Connor, that the disturbance which had happened inside of the store, a little verbal, the reason that we were there. And so Officer Smith came outside and figured out what I had learned on we have injuries, an assault occurred, they're in a dating relationship. This needs to be separated by arrest. So we both went back inside of the store, believing he'd still be right there with all his groceries. And all of his groceries and his cart were still by the counter. And we asked the workers, where did he go? And they said that he was walked the back of the store.
Let me stop there for a second.
Yes, sir.
You stated one thing that I failed to mention. You all determined that these two individuals were in a dating relationship.
Yes, sir.
Okay. And you could state that affirmatively, that you did that as well, correct?
I'm sorry.
You determined that as well, correct? That Mr. Connor was in fact dating Miss Victoria.
Yes, sir.
That's the nature of family violence.
Yes, sir.
Yeah. All right. So where did you ultimately find Mr. Connor?
He was inside of the restaurant at the back of the store.
What were your concerns about, hey, he's not where he said he was going to be, he's in the bathroom?
My concern is he knows what happened. He knows what she's going to say. He knows where he's about to be going, be in jail. He's discarding some type of evidence, firearm, weapons, narcotics, nothing like that.
You think he's disposing contraband or evidence?
Yes, sir.
Right?
Yes, sir.
So did he come out?
Yes, sir.
Did y'all handcuff?
Yes, sir.
Did he give you any problems one way or another?
Yes, sir.
Right. So you thought there might be contraband. So what did you do?
I walked in the bathroom, looked inside of the trash can, which was immediately to my left.
What'd you find?
He knows it. I typically call it a crack pipe. It's a clear glass pipe with a bulb on the end of it, which had burnt residue of some type of drug paraphernalia.
Anybody else in the bathroom?
No, sir.
So he was the only person?
Yes, sir.
Did you take that item?
Yes, sir.
And what'd you do next?
I think that I showed it or I stepped out of the bathroom and then thinking there's more. It's kind of a saying that we go by. It's typical of you find one thing, there's going to be something else.
Yes, sir.
I remember that, walked right back over the trash can.
Did you find something else?
Yes, sir.
What'd you find?
A clear plastic bag with crystal methamphetamine inside, what I believe to be. There's a plastic bag wrapped around itself.
Did you take those items into possession for
Yes,
those reasons? I'm reading your report. It looks like y'all decided not to charge him with the possession of paraphernalia.
Yes, sir.
And those items were actually destroyed, were they not?
Yes, sir.
So at the end of the evening, y'all just processed the family violence assault, correct?
Yes, sir.
Did anything else take place that you're here to testify about, Officer Holmes? That's right.
Warrant officer.
Now this alleged incident, you didn't see it happen, obviously, correct?
The assault?
Yes.
No, sir. I did not
Okay.
see.
You and your partner were called to disturbance, so y'all got there after the incident happened. Y'all responded to that, correct?
Yes, sir.
Okay. So the only thing you're going by is what you were told by the alleged victim and what you saw on her, correct?
Yes, sir.
Okay. Yeah, that's it. You didn't see it. You're reporting to the court what you were told and what you saw, right?
Right.
Okay. Yeah. And you can't say if she was telling you the truth or not, can you? No. Okay. And like I said, it's not your job to decide that. It's your job to present what you saw and heard, correct?
Yes, sir.
Okay. Now, as far as the stuff found in the bathroom, He had been in the restroom before you checked it, correct?
Yes, sir.
Okay. But he wasn't the only one that had been in that restroom before you checked it, right? Okay, yeah. There are probably many people throughout the day going in there, right? Okay. And the drugs and then the pipe and all that wasn't found in his person, was it?
Correct.
Okay. And ultimately, y'all decided not to charge him with that because you couldn't really prove or state that he was in possession of it, there, right?
Yes, sir.
Enough to come to court, right?
Correct.
Okay. All right. That's what it is.
No further questions, Judge.
Is this man excused?
Yes, please.
You're excused, sir. Thank you. Next, please.
State's Express.
What says defense?
Your Honor, regarding this issue, I think my client's already testified regarding all the other stuff.
Is there anything the state wants to, defense wants to present?
Not regarding this.
All right, summarize. State may go first and close.
Judge, I'll remind the court the call out for this original case. May I ask, Judge, do you have a copy of the PSI?
No, not with me right now. No, we don't keep those here in these files.
You'll note from the original PSI that led to the items that Connor was on probation for is that 2 officers were called out for domestic disturbance. He was in an apartment and basically was refusing to let them come in. They had heard evidence of some form of violence going on, so they had reason to gain entry to determine safety of the individual. And the result is that that particular lady was assaulted. She would not move forward with charges. The offenses that he was placed on probation for was the struggle that ensued between Mr. Connor and the officers there that never should have taken place in the first scenario. That I point that out because that's the nature of what we're dealing with here. We've got a lady who is in a relationship with Mr. Connor. There's accusations about other time frames of assault, but specifically as to this instance on April 13th, we've got 2 different officers who observed fresh injuries that are in state's exhibits 1 through 4 that fit with what they were told. And the limited exceptions that we've got is that statements that were introduced is that Mr. Connor, who is in a dating relationship with Miss Victoria, caused those injuries. That's the nature of the lesser included offense of family assault that I told the court I would attempt to prove today. I believe that all the elements of those are there for the court to consider in a scenario for ponderance.
Now you're speaking about assault.
Family.
Under section 22.01, the
Yes,
lesser
sir.
included offense,
Yes, sir.
which defines assault as being a person committing an offense if that person intentionally, knowingly, or recklessly causes bodily injury to another, including the person's spouse.
Correct.
All right. And
So I'm asking for a finding of true as to that lesser included offense as to count 1 in combination with the remainder of those counts. Once the court enters its ruling on that, I'll have an opinion about the resolution.
okay. Defense?
Yes, Your Honor. Regarding the allegations, and I'm going to take them separately here, the ones that were discussed in the first hearing, he pled true to those. Okay. So those are issues here where we're asking the court to give him mercy. One of them is the money he couldn't ought to pay. He paid what he could. So I don't think that's an issue for the court. As far as the anger management goes, it's something that he still had time to do. And we would suggest the court, if the court continues on probation, he can get that taken care of. As far as I think the big one here on these is the being out past his curfew, because we know that he was out past his curfew because that's when this alleged incident happened, and he even admitted that they were there. He mentioned that his car had broken down, that they were stuck there, and it wasn't intentional trying to be out past his curfew, guys. I think based on those, the court should have some kind of mercy on him and some kind of administrative sanction or something like that, and continue him on probation. Now, the big one we have here is the new offense. This is the one we were talking with today. I would argue that the state has not met their burden to prove up that this happened, in the sense that the victim was not here to testify. One of the things is in an assault is I don't want to say consent, that's not the right word, but that may be what I need to say, is that if he did do what they're alleging he did, is without the effective consent of the victim. Okay. And we don't know that. Okay. That's the problem here, is the victim's not here to testify what happened, what was going on, more of the details. All we have is what the officers were told that night and what they saw. Okay. And that's what I asked the officer about. And he's doing his job, doing a good job of just reporting what he saw that day, what he was told that day. But we don't know what was going on, because the victim, the alleged victim, is not here to testify. Sometimes assaults are not assaults because there is consent. And I don't know if this is a situation where it was. We just don't know. That's the thing. For example, if
That would be an affirmative defense, right?
yes, but there's nobody.
You could have called the lady.
Well, she doesn't want to cooperate. That's the
I don't
thing here.
care.
That's what I'm saying.
It's not for me to
yeah,
decide. I mean,
she
but
has not.
there are methods of bringing someone forward. If it's important enough, that wasn't done in this case.
Well, they still have to prove all the elements, and that's what I'm saying.
But you're saying you're stating an affirmative defense. That's not for them to.
I don't think it's. I'm not sure it's a affirmative defense, Your Honor. They still have to prove all the elements of the case.
No. Once again, it's intentionally, knowingly, or recklessly causing bodily injury.
Right.
Consent isn't in those elements, or
Yes,
lack of consent is not in the elements.
Right.
So that's not.
But still, the point is, Your Honor, the victim, they did not have anyone here testify regarding that. All they had was the officers testifying what was made available to them. And like I said, the officers doing their job. I'm not saying anything negative about the officers, of course. They were just reporting back to the court, or testifying to the court what they were told. And I don't believe that that's enough to establish that he committed an offensive assault. Okay. So I would ask the court to make this ruling on the offense or the allegations that he pled true to, and we're not denying or defending those, and set his punishment accordingly to those, and not to this alleged new offense.
Any rebuttal or summary?
I don't think it's necessary, Jeff.
Okay. All right. There is no debate on allegations 3, 4, and 6. I'm sorry, 2, 3, 4, and 6 of the motions to revoke probation, as in each of those allegations, the defendant pleaded true earlier, voluntarily, knowingly, intelligently to those allegations, understanding and appreciating that a voluntary and knowingly plea of true to one or more violations of probation would be enough under law to grant the motions to revoke probation. Probation can be revoked. They can be found guilty and be sentenced up to the full range of punishment. So the court finds those allegations to be true based upon the affirmative representations, the voluntary statements made by the defendant in that earlier hearing we held in this case on June 16th, 2025. Allegation number 1, committing the offense of continuous violence against the family, and then what dealt with under section 25E.11 of the Texas Penal Code. And it states that a person commits an offense if during a period that is 12 months or less in duration, the person 2 or more times engages in conduct that constitutes an offense under, among other things, section 22.01, subpart A, subpart 1 of the penal code against another person. The state admits that there isn't that element of continuous violence under assault is not proven. Section 22.01A 1 is assault, and it is included in the elements of continuous violence as alleged for the violation. Thus, under law, it can be considered as a lesser included offense that could be used to subject the defendant to revocation of probation. And it states that a person commits an offense if the person intentionally, knowingly, or recklessly causes bodily injury to another, including the person's spouse. The court finds that the state has proven through evidence that the defendant did commit the offense of assault by intentionally, knowingly, or recklessly causing bodily injury. And it is also within the penal code definitions bodily injury under section 1.07 definitions under penal code states it bodily injury means physical pain, illness, or any impairment of physical condition. The testimony and the evidence presented shows enough that the victim in this case was exhibiting wounds or injuries from a recent occurring assault, and that together supports the conclusion that the defendant is in violation of his probation by committing the offense of assault on or about April 13th, 2025 in Jefferson County, Texas. Thus, the court finds number one to be proven true through the evidence presented today, and thus sufficient evidence is in the record to support these motions, first amended motions to revoke unadjudicated probation, and defendant's probation can be revoked. What do the parties say about what should be done next? State.
Yeah, I would re-tender that yes, that for your education, the defense is going to be asking for the second opportunity for this defendant. And honestly, he's already had that. 2015, he was given a chance at probation, which he failed at. That was resulted in him being a 4-year sentence. Really, the state gave him either a second or third opportunity whenever we gave him this probation that was deferred in 2024. And so what we're dealing with here is 9 months later, he's still committing assaultive type behavior. And he has no compunction about it doing it. He's out at 2:30 in the morning. And if he had any intentions of following your probation, this man would not have been there, would not have been in the circumstances, and would have walked in the pine narrow to try to prove his character. Instead, we have the opposite. I would recommend that for the protection of those here in Jefferson County that he loves to pray upon. I speak for the women that have been his victims in the past and ask that he get 8 years.
Which you're asking for 8 years in prison?
Yes, sir.
Go ahead.
Mr. Hanna is right. I am going to be asking to continue my probation regarding the allegations that he pled true to. Those are things that he can correct and fix and carry on, get his community service done, catch up on his money, pay, do his anger management. As far as being out past time, that was a big mistake, and I would ask the court to the court wants to give him some kind of administrative sanction, for example, some jail time as part of his probation and continue on probation. He's on deferred probation, or another alternative the court has, as the court's very aware of, revoke his deferred probation, put him on regular probation, and let him continue to catch up and do the things the court initially told him to do that he just hasn't got to yet. Anger management, community service, things like that, and catch up on his fees and fines. So we would request either to sanction him with some jail time and continue him on probation, or to move it from deferred probation to regular probation.
Do you want to say anything, Mr. Connor? This is your opportunity to speak, but make sure that you run whatever it is you want to think about doing by your attorney. Okay.
First of all, Jay, I was going to say,
Stand up, please. Thank you, sir. Go ahead.
Phil Stevens, lawyer and VA, as well as my probation officer. I see you guys for the, for the messing up on probation, not reporting and stuff like that, things that I did wrong. And I want to say that all those things about that young lady, it is not true. She was in a fight earlier prior that day, and that's why she was mad at me, because I kicked her out of my house because I didn't want to get evicted, because I had just got this apartment and I wasn't trying to lose it because I didn't have nowhere else to go. My mom left that apartment to me, so, and I've been having problems with this girl, but I love her, so I try to give her another chance but I'm getting to the point where she's not bringing me no good. She's only bringing me bad. And even if, like right now, I'm going through situations that I shouldn't even be going through because of her.
I'm sorry. No. You're going through the situations you're going through because you bit police officers, and committed assault on peace officers. That's why you're here in the first place.
Okay.
Don't forget, let's keep your eye on the ball. You shouldn't even be on probation. But no, you decided to commit aggravated assaults on peace officers.
First of all, I said,
You pleaded guilty to those.
I did.
All right, you want to take those back? You were under oath. You want to try perjury as well?
No, I'm not talking.
You looked me right in the eye and said, I did this. I want you to put me on probation. You remember that?
I'm not going.
Do you remember that?
Remember.
All right. That's why you were here, sir.
Okay. That's not what I'm talking about, Judge Stevens.
I know you wouldn't want to talk about that, but it's assaultive behavior. And this alleges another assault.
Okay, Stevens. To be honest with you, Judge Stevens.
Yeah, that would be nice. Be honest with me.
I didn't even assault those police officers, and I have proof of that. But I had a lawyer.
I want the state to consider filing a perjury charges for this man. He is making statements to this court, and you pleaded guilty voluntarily, knowingly, intelligently, under oath, saying I committed, and you're going to interrupt the court, Mr. Interrupter. You pleaded guilty under oath, and you're now looking me in the eye and saying you didn't commit those crimes? That's perjury.
I didn't even know that's perjury.
Don't you just think lying is just normal?
No, I just don't know.
It has consequences.
Nobody never taught me the law.
Yes, well, sir, we went over this real thoroughly.
I did.
Hold on.
I do.
Hold on. We're gonna refresh your memory. This is important. I need the affidavit, the plea paper on the entry of the plea on in either one of those. It's going to be the same one.
Y'all finished? Okay.
Stand by.
Yes, sir.
Oh, Lima,
Or-
Yes.
you're gonna be towards the back, on the right hand side. Not all the way back. I'll reprint them.
Yeah. I don't know. Sometimes they don't put those in. It's in there. They're in the record because they have to be in the record.
And it should go.
I just. What this court does not tolerate are false statements because we've got to work on accuracy. Now, this court knows that people don't tell the truth from time to time. And
You have a very hard one. No. Okay. I didn't know all. I don't even. I don't get in trouble. I don't work. I don't have no record.
hey, sir,
Yes.
be quiet. Thank you. What makes this court angry is that we really can't resolve matters when people can't tell the truth. And we know that happens. When they don't tell the truth, they get called on in this court.
I apologize to us once again. I didn't mean to not say you.
Well, maybe you just don't understand what perjury is, but it's lying under oath. Here is a statement you signed. This is your signature. There you are, right there. See your signature? You can see it. All right. See this yellow part? All right. This is sworn under oath. This is what we do in every case when people enter pleas of guilty and when they want to enter a plea of guilty. And this is duplicated in each case. And this is charging you with assaults on a peace officer that you were placed on probation for. I have read the charging instrument, the indictment, and my attorney has explained I committed each and every element alleged, which means you are admitting to assaulting the peace officers that a few moments ago you said I didn't do. I am guilty of the offense and all lesser included offenses charged against me in this case. Listen to this part. This is really the catch. I swear that all of the following, as well as the testimony I give, is the truth. So help me God. So you interrupted once again. Let me make the point. You admitted under oath you were guilty. You swore to God it was guilty. And then you have the audacity here in this proceeding to say, I didn't commit those crimes. You just admitted or made a statement that is completely contradictory to what you swore to under oath. That's what we call perjury. Now, you want to take it back?
Yes, sir.
See, the problem is that you lose all credibility when you get caught lying under oath. And that's what we're trying to figure out, is what the truth is.
The truth is, I wasn't never talking about those stuff like that.
Oh, we're going to believe you now?
But I was trying to tell you about a situation that I was having with this girl. But anyways, the thing about it is, look, Stevens, I truly apologize for everything that I've done. all along those situations. I mean, I try not to do wrong. I try to do the right thing.
It's somebody else's fault.
It's never nobody.
Is it your fault?
It's always my fault. Just
It's always your fault.
It's
I'm
always-
talking about just this. I'm not saying asking you to take the blames for all the sins of the world. I'm talking about this case, this hearing, these allegations. Are you accepting responsibility for
I'm
it?
not just simple responsibility for those.
Okay.
As far as assaults for the police officers, yes, I accept the
Oh,
responsibility.
that's not what you said a little while ago,
And I
was it?
accept the probation. But just because I mean, life has been kicking me in the butt, man. I mean, I just,
Sir?
I said, like my life, but things just hasn't been going very well.
Sir, life is what we make of it.
And I understand.
And everybody makes choices. Everybody makes mistakes. It's how you deal with your mistakes.
Yes.
You have made serious mistakes that you have not dealt with responsibly. And at this point, the way you respond to it is defiance. I didn't, by getting caught in a lie here, I didn't even assault those officers, even though you admitted under oath you did. That's what's important. We don't take these allegations lightly. This is serious. We have to rely on the evidence. We have to rely on sworn testimony. We have to rely on the truthfulness to get to the bottom, and that's what this court has to do. This lady is injured, and it's clear that you were found responsible according to the investigation. And this court finds from the evidence presented that it meets the definition of assault. But you were on probation for assaulting two peace officers. You have no business assaulting another person, much less someone. Your relationship with this lady was what? Were y'all married or?
We was planning on getting married.
Okay. You were in love with her.
But just think,
Wait. You were in love with her, right?
Yeah, I was in love.
Okay. This is, if you are going to assault peace officers who are doing their job, if you are going to be assaulting someone who you claim you love, what would you do to somebody that you didn't like?
I think it was something. Look, just she got in a fight. She was mad. She was mad because I was kicking her out of my house. I'm telling you.
Somebody else's fault, isn't it? It's somebody else's fault. Just like I didn't really bite those officers. It's somebody else's fault. Sir, we learned, I know I learned when I was young, you make mistakes and you're going to be held accountable when you make the mistakes. So you try not to make mistakes. And you certainly don't want to get caught in a lie when you were under oath, when you said a different statement. You, sir, just have a problem being truthful. You have a problem dealing with other people responsibly. The way you deal with issues is to assault. You use violence. No, sir, you have a rich history of doing that. You were pleaded guilty to 2 assaults. You pleaded guilty under oath that you tried to lie about a little while ago. Then this court has found sufficient evidence that you committed assault while on probation for assault. You are going to be held accountable. It's something you don't like, being held accountable for your mistakes, but we all are. We all are. And
Okay, so
is there anything else you want to
I
add?
just want to say, just the first of all, on me. Listen, please listen. I mean, you saying about how the way it was when we. I never had my father, and I didn't have nobody to help raise me and stuff like that. But
It's
that's what I'm trying to say.
life's fault.
I never assaulted that girl.
Yeah. Let me ask you this.
And that's
How many misdemeanor convictions do you have,
Probably about 2.
sir?
I don't know. Probably about 2 or 3.
Wait, this is your life. This is your life. Nobody knows better than you. You don't know how many misdemeanor convictions you have had?
Probably had about 2 or 3 of them. I don't know.
All right. Let's see. It starts off in 2009, illegal possession of marijuana. You were put on probation and that was revoked. Criminal trespass in 2010, 30 days in jail for that. Illegal possession of marijuana in 2010, 30 days in jail for that. 2014, failure to identify, 30 days in jail for that. 2014, evading arrest and detention, 30 days in jail for that. 2014, resisting arrest, 30 days in jail for that. 2016, failure to identify, 150 days in jail for that. 7. Resisting arrest and search in 2024, 120 days in jail for that. And assault causing bodily injury to a family member in 2020, 60 days in jail for that. What do we have? 9. You said 2? You know more about your life. You got 9 misdemeanor convictions. Plus, how many felony convictions do you have? Evading arrest or detention with a motor vehicle that you were on probation for in 2015, and that was revoked in 2018 because you couldn't stay on probation properly, and you were convicted of that. And that makes you a felon, which means you can't even get probation by a jury on anything. And now we have 2 more assaults of peace officers. You're looking me in the eye and trying to sell me with I've only got 2 convictions, and these are 10 plus 11, 12.
So, Steve, I'm just trying to look you in the eye and tell you that I'm not no criminal. I'm not a criminal.
12 convictions is a criminal, sir. You got the wrong definition.
I wish I knew the law just a little bit better. Then I'm going to make sure I learned that law.
That's not the problem with you. It's following the law. It's your fault.
Hey, that's very much I mean,
I know. That's the problem with this. And people get assaulted. Police get bitten. And your statement is, I'm not doing anything wrong.
I hit the girl 5 times. Do it look like I hit her 5 times? First of all, I didn't hit her not 1 time.
Anything else?
Just Steve, okay, if you're going to make it, give me more probation or something, but I don't want to. It's your court.
Anything else?
You want to do anyway, but at the same time,
No. This is a product of your actions, not mine, sir. You have proven to be not only a criminal. Now 12 convictions. 12 convictions when you tried to sell it with just 2, but you're committing violent offenses. You're committing assaults. You're dangerous. And you get caught telling lies. Your way of dealing with it is to try to lie your way out of it.
I don't have to lie.
No, you don't. And that's the incredible thing about it. You do it anyway.
I didn't lie not 1 time.
You just said, I'm sorry. Didn't you say I had 2 convictions? Didn't you say I had 2 convictions?
I only wanted to get out of jail.
Didn't you say that I wasn't guilty of biting these officers when we showed under oath you stated you were guilty?
I apologize to you for that.
Oh.
Can you please have mercy on me?
If I'm going to be fair with you,
You don't mind?
you didn't show mercy on the police. You didn't show mercy to this lady.
I promise to follow with all my stipulations on probation.
All right.
I promise to get started my payments. I promise to do everything that I need.
You made those promises. I'm sorry. You made those promises when you were placed on probation that you didn't follow. So
I was homeless, Judge Stevens. I didn't even have nowhere to go when I got out of jail. My mom was getting ready to die. She died, actually. She filed lawsuits and stuff that I'm dealing with right now. That's why I didn't able to report. Look, I was going through a bad state at the time when my probation officers was telling me to report it. I had just lost my mom. She was in the nursing home, first dying.
we have thousands of people on probation. 92% are successful. They have the same issues, sir, and they are able to take care of their business like they are responsible. And you just can't help but interrupt me, can you? You interrupt. That's what you do. You don't follow the rules of decorum. You don't follow the rules of law. You have it your way on your terms, and everybody else suffers. There is sufficient evidence supporting these First Amendment motions to invoke unadjudicated probation in each of these cases, to grant them by a preponderance of the evidence or greater in cause numbers 35195 and 35435. As allegations 1, 2, 3, 4, and 6 have been proven true by a preponderance of the evidence or greater, and the court finds there is evidence on allegation 1, the lesser included offense of assault is proven beyond a reasonable doubt to support these motions to revoke probation. They are granted, and your deferred or unadjudicated probations are revoked in each of these cases. In each of these cases, you pleaded guilty to assaults on a peace officer, something you attempted a little while ago to try to deny until we showed you that you had sworn under oath admitting to this. You pleaded guilty to those cases voluntarily. You were mentally competent to do so. You understood and appreciated the consequences of pleading them. There was sufficient evidence supporting your guilty plea from State's Exhibit 1 admitted in each of those cases. Your sworn instruments, sworn documents admitting culpability in those crimes. That is enough to find you guilty beyond a reasonable doubt, and I now find you guilty beyond a reasonable doubt of those 2 second-degree felonies, which puts you into a position of no less than 2 nor more than 20 years confinement in prison. I find you guilty beyond a reasonable doubt as your probations are revoked, and you were hereby sentenced to confinement in the institutional division of the Texas Department of Criminal Justice to serve a term of 8 years. And those 2 sentences shall run concurrently. All right. Anything else? Anything else from the defense? All right. We are in recess.
Yeah.